and the repeating of the stories, making up stories. All right, is this a legitimate issue? Could this overturn the verdict? Let's bring in our think tank. Joining us tonight in Atlanta, Georgia, criminal defense attorney Michael Bixon. In the Bronx, New York, criminal defense attorney Renee Hill. And in South Orange, New Jersey, media law professor and legal journalist Candace Kelly. Great to have everyone here. Michael, I'll begin with you. And I will admit, as a young prosecutor in one of my first trials, in my closing argument, I believe I was doing an impression of the defense attorney, mocking him a little bit.
Oh, ouch.
Yeah,
ouch.
Yeah. The appellate division at the prosecutor's office not happy with me but it's just the conviction stood. Okay, it withstood that, but it was probably a little bit over the edge. What about what we just heard in the allegations, Michael? Is this a legitimate issue?
It's borderline. I definitely think that it's an appealable issue. The question I think that the appellate courts, at least for this specific issue, and there's some other ones as well that I'm sure we'll cover, but for this specific issue, I think the question is it going to, or would it have affected the jury's outcome? And, closing arguments are obviously a very important part of any case. I mean, this is the last piece of argument they're going to hear from the state or the defense. They're very persuasive. And if you hear a prosecutor sort of stepping over the bounds of what they're supposed to argue, yeah, it could have a very serious impact on the jury. But that being said, whether or not it actually affected the jury's outcome, I'm leaning towards no, but I still think it's a good, issue to bring up on appeal.
Renee Hill, what are you going to do if the prosecutor in his closing argument is talking about how you were spewing out a bunch of nonsense, that you were shading the truth, and you were telling stories to the jury?
Vinny, during the summations, parties are allowed to characterize not only the evidence, but characterize the arguments of opposing counsel. And I have, at times, called the prosecution's argument ridiculous, that it's nonsense.
But you're a defense attorney. You don't have the same. You don't have the same obligations as prosecutors do you?
This is true. Well, you still both have to be ethical, right? And you can't just say anything. So you have to walk a fine line here. So Eric Nelson, he's making the argument that he has to make. He objected. I think he should have objected to some other things that he didn't, but he's preserving the record. He's doing his job. Whether or not this is going to fly on an appeal, I don't believe so. But I think that, it was a fine line that Jerry Blackwell was coming up on. So yeah, he was getting there.
And Candace, Jerry Blackwell, not a prosecutor. He's a civil attorney, and rules might be a little bit different in the civil courtrooms than the obligations a prosecutor has. But did you hear prosecutorial misconduct?
I heard a lot of pushing of the boundaries there when really, besides the word that he was using, he was saying that they were lying. I mean, when we say that someone's telling stories and shading the truth, they're saying that they were lying. Now, would I think that this would cause some type of mistrial? Probably not, because then you're really, like you said, you're asking yourself, would the jury decide otherwise if they didn't have this piece of information in the closing argument? I think the jury's on their own, and people who were in them, especially we've heard from one of the jury members today, I think that they on their own have decided that they were shading the truth and that there were stories and that was part of what they heard on their own. So I don't think that that's anything that they would find any other way if it was appealed.
All right. Another big part of this was a request by the defense. They wanted a change of venue. They wanted sequestration. And a lot of it had to do with a lot of things that were happening before the trial, during jury selection, during the trial. Including that record civil settlement of $27 million. Here's Eric Nelson in court, and this is during jury selection, making his objections to the way things are proceeding.
I am gravely concerned, and I know we've been dealing with these motions this morning, but I am gravely concerned with the news that broke on Friday relevant to the civil settlement in this case. This is, by my count, notwithstanding all of the high-ranking state officials that made comments at the onset of this entire situation, but by my count, this is the third highly prejudicial and incredibly prejudicial press leak or press release that has very suspicious timing, to say the least, and has an incredible propensity to taint a jury pool. Because what we've been hearing from the jurors who've come in so far is they may run into a headline record $27 million civil settlement. If they're and the court has granted permission for these people to be scrolling through Facebook, it's going to be unavoidable. And I think that there are certain things that the court should strongly consider. I think there are things that if the court denies those requests, there are things that the court should potentially be obligated to do to protect the jury from future questionable press releases. If the court is not inclined to continue or change venue, and we can address these again further, I think there are things that the court must do, which include calling back the 7 jurors that are currently seated on this case and inquiring. I think there needs to be specific inquiry as to this settlement. It's amazing to me is, you know, they had a press conference on Friday where the mayor of Minneapolis is on stage with city council, and they're using very, what I would say, very well-designed terminology. The unanimous decision of the city council, for example. It just goes straight to the heart of the dangers of pretrial publicity in this case. I think the court should also strongly consider providing the defense with extra strikes. It's another potential remedy. And I think the court should strongly consider the immediate sequestration of jurors throughout the pendency of this case.
All right, again, they're asking for sequestration, change of venue. Let's take a look at what the mayor, this is a piece of that press conference he was referencing that happened in the middle of jury selection.
Every American remembers where they were when they first saw it. When they first were forced to process the incomprehensible, recognizing our historic shortcomings and what we need to do to improve going forward. There are certain events like that in world history that seem to suspend time, where the world stopped. And those moments tend to stick with us. And our Black community has endured deep and compounding trauma over this last year, none perhaps more acutely than George Floyd's family standing with me right now.
All right, Renee Hill, $27 million in the middle of jury selection, no change of venue. Is this going to be part of the appeal, and is this a legitimate issue that all this other stuff is going on? The city of Minneapolis admitting guilt.
I definitely think it's going to be a part of the appeal. It will be put into the paperwork. And again, Mr. Nelson was doing what he needed to do by preserving the record. I don't know that it's going to be enough. I certainly don't think it's going to be enough to overturn this verdict here. This was a monumental verdict. But the judge addressed his issues, and he did question the jurors. And I believe 2 of the jurors were removed after they indicated that learning of the settlement could, sway them. So I think with the judge addressing it, it set things back in order. He did speak with the other jurors. They said they were fine, and they moved forward. So it's something, again, for him to talk about. It's something that they can put into the papers, but I don't think it's going to be enough to overcome what has happened here.
All right, Candace, I want you to take a look at this now. Defense attorney Eric Nelson also went on the record at the start of jury deliberations regarding government officials commenting on the trial publicly.
Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating a jury demanding that if there's not a guilty verdict, that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned.
All right, so Congresswoman Maxine Waters was at a protest for the shooting of 20-year-old Dante Wright in Minneapolis that weekend when she made comments about Chauvin's trial. Here's some of what she said.
I am very hopeful, and I hope that we're going to get a verdict that say guilty, guilty, guilty. And if we don't, we cannot go away.
All right, Candace Kelly, is this a legitimate issue on appeal?
Not at all. And I think that Judge Cahill spoke out of turn. What did she say that we didn't know was already going to happen? That if the verdict didn't come down the way that the general public that was on the streets wanted to, that they were going to continue marching. She didn't ask for anybody to intimidate anybody, threaten anybody, do anything in terms of any acts of violence. So I think that this was completely out of turn. In addition to that, the jurors already had their marching orders. They were told not to look at anything that was in the media, though I do think they should have been told not to look at social media and things of that nature. But they had their marching orders to be impartial jurors. We have to trust the system at some part. We trusted it up to this point, all the way to the end. This is not something that I think will be any issue on appeal.
Michael Bixon, all right, how about the totality of the circumstances? You've got this trial, this settlement, Maxine Waters, protests taking place in the middle of it. You've got the shooting death of Dante Wright 10 miles from downtown Minneapolis where all this is taking place. You have the family of George Floyd testifying in court and then speaking about Dante Wright in front of the courthouse. All this going on with a non-sequestered jury. Does that add up? If you take a look at the totality, could it add up to be enough to overturn a verdict and get a new trial?
Absolutely. I think that between the sequestration issue as well as the other issue of, this change of venue, when you look at all the events that happen, if it's just one thing or another, not so much, but everything that happened throughout this duration of the trial, I absolutely think that he's got a great issue on appeal here for those two issues. One, the venue change, and two, the sequestration. And like I said, when you look at the statements that were made by elected officials, when you look at the things that happen outside the courthouse, I absolutely think this is going to go towards, an appellate court looking and saying, did this influence the jurors? And even though they were instructed to, stay away from the news, they still have their cell phones. And when you scroll through things like Facebook or Instagram, it's impossible not to see these things. And even if you try to disregard them, they will have an impact on you. So I definitely think it's a good issue for them.
Now, Renee Hill, here's my prediction that there will not be an overturning of this verdict, right? But I could be wrong, and I think these are legitimate issues that are all going to be brought up. I know nothing about it. But if they don't, if this verdict stands, do cases like this that are so high profile with so much happening end up making bad law for future defendants?
That's a hard question to answer because every case is different. Every jurisdiction is different. This case is a game changer, absolutely. Is it bad case law for defendants? Not necessarily, because at the end of the day, when a case is this publicized, the court is very, very careful. They don't want the case to come back on appeal. So they are being extremely cautious. They are making sure that the rulings that they're handing down are on point, are extremely fair, or at least they're trying to be fair, because they don't want the case to come back on appeal. So everything that happened here in the Chauvin trial, I think it was a very fair trial, and I don't think it sets bad case law for defendants. It was a very fair trial for both sides.
All right, yeah. Judge Cahill, very thoughtful in all the decisions that he made, and we'll see. But as Michael said, and I agree with Michael, that this is going to be fought. This is going to be a real battle at the next level, too. But again, the good news for prosecutors, anytime you're talking about an appeal, we won. All right, when we come back, just before this verdict happened, there was another shooting, not in Minnesota, but in Ohio, Columbus, Ohio. We'll show you the video. You'll hear the 911 call. And then we'll talk about whether or not any crime was committed. That's next.
And I wish Micaiah was still here with me, my baby. I wish she was still here.
I do too.
I wish I could hug and kiss her again, and I can't. I can't hug my baby. I'm hurting. I loved her.
And that's Micaiah Bryant's mom. Micaiah Bryant, 16 years old. She is the young woman from Columbus, Ohio, who was shot and killed by police. She had a knife in her hand. She was in the midst of an altercation, and it appeared like she was about to use that knife on another teenage girl when the officer discharged his weapon. I'm going to give you a graphic warning. We're going to show you that video right now so you can see it. We're going to start with the 911 call, and you'll see some footage from the scene after the shooting, and then we'll show you the shooting, and it happens very quickly. So let's take a look so we can talk about it.
911, where is your emergency? 911.
Hello? Lead your way.
Is there an apartment number letter? What's going on?
Come up here.
Ma'am, you need to talk to me.
We got these grown girls over here trying to fight us, trying to stab us, trying to put her hands on our grandma. Get here now.
Have you seen any weapons? Ma'am, do you see any weapons?
We need a police officer here now.
Do you see any weapons?
Police officer now.
Ma'am, do you see any weapons?
The dog's trying to hear us. No!
Hey! What's going on? Hey! 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 Get down! Get down! Get down! Get down!
No! You ain't shoot my baby! You shot my baby! Are you serious? Are you stupid?
True.
She shot.
Back up.
And she shot.
She had a knife. She just went at her.
She's a idiot, man. Damn, are you stupid? Hold on. I told you something like that. I told you something like that. I'm on my chair. Why? I'm telling you now. That shouldn't even be.
She just hit at me. I just got here. Babe, it's okay. Calm down. It's okay.
Yeah, 200. We need more cars for our witnesses.
Okay, I've got a 10-3 roll. I need more cars.
Have a seat. Work quick.
Don't say nothing. Keep your hands up.
200. Is this still involved?
I do what?
I do. I understand.
Hey, firm. Have a seat. Have a seat. All right, come sit over here in this car. Ma'am, come sit here. Go ahead and have a seat.
I just pulled up here.
Let's hurry up, please. This is urgent. Have a seat, please.
Chaotic and very tragic. Let's bring back in our think tank. Candace Kelly, watching that video, did you see a crime committed?
Listen, I know one thing is for sure, that this officer did make a split-second decision. And two, it looked like that young lady was going to stab someone. But the problem is, what do police officers do in that situation that makes sense, where someone doesn't end up dead all the time for something that may not have escalated to that point where a death should have been involved? So that's really a question that's left up to them in terms of their training, how they carry out what they do. As an outsider, again, it looked like a split-second decision, and it did look like somebody was going to be stabbed. Now, people are asking the question, well, why didn't he shoot her in the leg as opposed to the body mass? And we know that he could have probably shot other people if he shot them in the leg. Again, retraining in terms of trying to de-escalate. But it's a very tough call, very tough for me to answer that question.
Michael Bixon, did you see a crime committed there?
Not on the part of the officer. I mean, it's always terrible to see any loss of life, especially with someone this young. But when you watch the video, it's pretty clear that she had a knife and that she wasn't just sort of in the middle of the road with it. She was about to stab somebody, at least from what it looks like on the video. And in that context, no, I absolutely don't think that the officer committed any crime.
There's a freeze frame from the video. Renee Hill, do you agree?
I have to agree with Michael and Candace. You know, it was a split-second decision. It's very hard to watch. It's very heartbreaking that, again, a young life has been taken. But, you know, the police do have to be retrained. I completely agree with Candace on that. And I don't understand not being in law enforcement. I get it. But just shooting to kill, I know it's split second, but I just think that there has to be a better way. There has to be a better way.
I will tell you, we've run this by. We have our crime time segment. We bring in law enforcement professionals, different experiences, all of them, and so far all have agreed that that's what they would have done in that situation as well. So we'll see, though. It's a continuing conversation, obviously, and created a lot of reaction. As part of that reaction, NBA star Lebron James weighed in on the Ma'Khia Bryant shooting in a since-deleted tweet that was posted online by the New York Post. And in it, LeBron James wrote and put a picture of the officer, right, and then said, "You're next," with an hourglass and then hashtag accountability. I wanted to throw almost the same question at you, Candace. I'll start. Anything illegal or actionable about that tweet that was sent out to 50 million people?
Oh, that's a problem. That's a real problem, because what you're saying is that this officer did something wrong. You're saying that this was the officer, in fact, that did the shooting. He didn't really know at that time. He's really trying to ruin this person's reputation, defame them by pointing this out in this way to, like you said, 50 million people. When you are filled with passion, filled with anger, it's not a good time to tweet. It's just a better time to delete, and that's what he did. Mm-hmm. But once that's out there, it's too late. You've already done the harm. And I would expect that there would be more actions from whoever was in that picture against LeBron James, and he should be the one who's concerned at this time. Understanding, again, that he was angry, passionate about it, but unfortunately, this was a mistake.
Michael?
I absolutely agree. I mean, you're next. There's a lot of different connotations that could come with that, and most of them are definitely not good, whether that meant as some type of threat or whether or not that meant that, there's going to be some type of legal action taken against him. I just think it was way too broad. I think that it could be construed the wrong way, and it was a great idea for him to delete it. I think it would have been an even better idea for him not to post it in the first place, though. Any advice for
King James tonight, Renee?
He should listen to his PR people and talk to them before he tweets out anything else like that.
All right, when we come back, we're going to talk about the next big trial here on Court TV. It's out of Missouri. A young woman is found dead 2 days before her wedding. Her fiancé was actually married to another woman, and now he's been charged with the murder of his fiancée. Oh, and by the way, his wife did divorce him. All of that next. On the docket tonight, the next big trial here on Court TV, and it involves a man named James Addy. We have a picture of him. It's actually a mugshot because he has been arrested. And James Addy, there he is, has been charged with the murder of a woman named Molly Watson. And many of the details that we're finding out about the allegations here are outlined in a probable cause affidavit. And in the first part of this probable cause affidavit, they tell the story of a witness, and we don't know his name, but there was a witness who's driving in this low water crossing in a remote area of Missouri and comes across a guy, a male subject, they refer to him as, has a conversation with him, and there's another car there. The conversation is so weird that he goes back to the area after he leaves, and he finds Molly Watson dead and then calls 911. That's how it all starts. But the witness who had the conversation with this man, you know, it was a strange conversation. So kind of like, he's like, I got to go back there just to see what was going on. I want to bring it back in our think tank. This is how the story begins. Now, here's my question, Renee. If this witness cannot identify, can't ID the defendant, James Addy, as the man he saw in that low water crossing, how bad is that for prosecutors? Is that the end of the case, or can they perhaps make it up through some sort of forensic evidence to place him there?
Well, certainly if there's forensic evidence that places him there, that's going to be a lot better than having an eyewitness whose identification could be off. But certainly if he cannot ID Mr. Addy as the person that was in that area, that is a problem for the prosecution. And they are going to hope to have something else, like forensic evidence that puts him there.
Yeah, it's interesting because the way the probable cause affidavit's written, it's not clear if he is able to identify anyone at the time. So we'll see. And the prosecution has not released a lot of information. Now, they find Molly Watson, Candace, and they decide to check online and social media, and that's when they find out that she was about to be married in 2 days. So they went to the house of her fiancé, who's James Addy. And James Addy starts talking with police and says, oh yeah, I've been married to my current wife for 22 years, and I've been in this relationship with Molly for 7 years, and yeah, we were supposed to get married. He ended up saying, quote, I got myself involved in something I shouldn't have.
You know, that could mean so many things, couldn't it? It could mean he got himself involved in killing Molly. And number two, he certainly got involved in dating Molly for 7 years, being married for 22 years. It's like he's never seen anything on Lifetime TV. You know, I think that when we look at all of the evidence, we were talking about the car in the garage and the tracks that were there. He definitely got himself into some trouble that is going to be very difficult to get himself out of, regardless as to whether or not the witness is able to identify him or not. This circumstantial evidence, and from what I understand, you still might be able to Google their online announcement of the wedding. This all just makes him the number one suspect. It's going to be very, very difficult for him to get out of this. He was right when he said he got himself into some trouble. He certainly did.
Now, Michael, exactly what Candace was talking about. It's definitely a scene from My Cousin Vinny at this point with the tire tracks. The tire, and this is part from the probable cause affidavit. The tire tread on the Mercury Sable was consistent with the tire imprint located at the crime scene. Addy admitted driving that night, but he said he went to go visit a friend who wasn't home at the time. So, tire tracks. What do you think in terms of expert testimony? I mean, is that going to be, how persuasive will it be? Because I can see a defense attorney saying, do you know how many sets of these tires there are in Missouri, right?
Sure. I mean, I think it's definitely an issue that they're going to bring up. You know, how much the jury is going to really look into that, and how much they're just going to be blindsided by all the other circumstantial evidence that we have here, namely the status of the relationship, whether or not they can even get past that to even sort of look into this point. I think it's going to be a difficult issue. When it comes to tire tracks and other sort of evidence like this, I definitely think that there are holes in it for the prosecution. But again, yes, it's circumstantial, but there is a lot of circumstantial evidence in this case that is really not good for him.
Yeah. Renee, I'd be interested in hearing your opening statement if you're representing the man with a fiance and a wife. But we'll save that for during the trial. We'll be there next week. All right. When we come back, there was a verdict, as we know, in Minneapolis this week. Derek Chauvin, now a convicted murderer. It's not over, right? We talked about the appeal tonight, but let's also talk about what's going to happen in 8 weeks, which is the sentencing of Derek Chauvin. The presumptive sentence is 12 and a half years. But prosecutors want to upwardly depart from that based upon some aggravating factors. They want something, we believe, that'll be much closer to the maximum of 40 years. How much time do you think he should spend behind bars? Your verdict when we return.
State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota plaintiff versus Derek Michael Chauvin, defendant. Verdict, count 1. Court file number 27, CR 20-12646. We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:44 p.m. Signed, juror foreperson, juror number 19. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Signed by jury foreperson, juror number 19. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Jury foreperson 019.
All right, the verdict's guilty, but what is the punishment going to be? Now, in Minnesota, they have sentencing guidelines. It's like a chart, and you calculate the defendant's criminal history. And here it's a 0, and then you line it up with what the offense is, and then it gives you a guideline on what the sentence should be, a very small range. But in this case, prosecutors are saying, no, you shouldn't be in that range. You should have a much higher sentence based upon some aggravating factors, like the fact that George Floyd was handcuffed and vulnerable. It was done in front of children. He was in a position of authority, arguments like that. So 12 and a half years is the presumptive sentence, but what should he get? That's what I asked you. We begin with our 13th juror comment of the day from Christy tonight, who says, life without the possibility of parole. That's not even a possibility, Christy. He is above no law, eye for an eye, but as I stated before, I truly wouldn't be surprised if he ended his life within the first year. Renee Hill, how much of a concern is that when someone is convicted of a murder and it's time for them to go to prison and they haven't lived a life of crime, but they've lived a life, this is their first offense. And is that a true concern, suicide?
Oh, absolutely. Absolutely. Especially an officer, someone who has spent his entire career, putting people behind bars, and now the shoe is on the other foot. And he's the one behind bars. And I'm sure it's extremely traumatizing to him. And he could fall into a deep depression. And suicide can absolutely become an issue. And I'm sure that, they will monitor him to make sure that he is safe and secure, and that he doesn't need any mental health, evaluations or anything like that. Suicide Watch is certainly available to him if they think that he needs it, and it is certainly a possibility.
Michelle tonight, 12 and a half. Too many other factors went into George Floyd's death for Derek Chauvin to get more than that. Candace, your thoughts about the presumptive term. This is someone who has no criminal record. And the presumptive term, 12 and a half years. Prosecutors are going to ask for much more.
Yeah, they're going to ask for much more, and they should. 12 and a half years, those are the guidelines. We use them as a guide, and when we look at the aggravating factors, there's several, and all you need is one of them. I just can't imagine that we have, a 60-year-old Derek Chauvin out of jail, walking around, getting ice cream and watching movies. It just doesn't sit right. It has to be more than that. It has to be more than the 12 and a half years. If they go up to the 40, I'll take it. George Floyd got a life sentence. That's the closest that we can get for Chauvin. That's why they call them guidelines, and that's why we have these aggravating factors.
Erica tonight, he should get the max for what he did. He didn't have any compassion for George laying on the ground with no pulse, so why should the judge? Michael Bixon, how much pressure on the judge in this moment?
A significant amount of pressure. I mean, I think between the public opinion, with what the news is reporting, I think he's under a lot of pressure to go well beyond what that 12 and a half years is. And how far beyond that he's going to go, I don't know. I do expect that we are going to see an increase, though, from 12 and a half. Whether we're talking around 20 years or so, I think that's pretty likely.
Gloria tonight, 40 years. His job was to serve and protect. He failed. Renee Hill, how does the issue of him being a police officer, is that an aggravating factor, abuse of authority, versus a mitigating factor that prior to that day, he lived a life in public service?
It's a double-edged sword. It certainly is an aggravating factor because he was tasked with protecting and serving, and he abused that power. And because of that, because he was an officer, he is supposed to know better. So to a certain degree, he is held to a higher standard when it comes to what he should and should not be doing. So, yeah, it does hurt him.
Peter, along the same lines, he abused his authority. He was a police officer sworn to protect and abide by the law. He should have known the law and been held at a higher standard for breaking the exact laws that he's there to protect. Absolutely, he should get more than 12, at least 25. All right, Candace, what do you think is a fair sentence here?
A fair sentence, 20 years. I would say that that's fair. But of the same token, if it's 40, I'm good with that too. I mean, let's look at what he did and what he did not do. He did not honor his badge. In fact, he did the opposite. He did not protect and serve. He killed.
Mm-hmm.
Candace Kelly, Renee Hill, Michael Bixon, great job tonight. Always great to have you all on the program. Come back soon, and we appreciate it. Thank you.
Thank you.
All right, thank you.
All right, folks, that'll do it for us here tonight. Of course, we'll be back tomorrow night, 8 to 11. We're here every night, taking you inside the world of crime and justice, all the big stories, all the big issues, and we'll break it all down for you each and every evening. Tomorrow night, by the way, we're going to take a closer look at the case against the other 3 officers, so you don't want to miss that. I'm Vinny Politan. Have a great night, and as always, don't forget to hug the kids.